So good morning, all. My name is Jean Pontes, and on behalf of the Harvard Law School Brazilian Studies Association, I welcome our audience to the event, Bridging the Connection Between AI Procurement and Ethics in Government Algorithms. We are very happy to have here two distinguished speakers with us today. The first one is Mr. Mason Kortz. Mason is a clinical instructor at the Harvard Cyber Law Clinic. His areas of interest include digital civil rights, government transparency, information law, and the law of artificial intelligence. Mason is also a lecturer at Harvard Law School, where he teaches a reading group denominated Algorithms, Rights, and Responsibilities. And Mason has a JD from Harvard Law School and a BA in Computer Science and Philosophy from Dartmouth College. It is a great pleasure to have you here with us, Mason. So we also have the pleasure to have Mr. Rafael Fassio with us today. Rafael is a São Paulo State Attorney and fellow of the World Economic Forum, where he studies artificial intelligence. Rafael is also the lead counsel for science, technology, and innovation in the state of São Paulo, and a former advisor to the Inter-American Development Bank on public procurement for innovation and open innovation in Brazil. He holds a Bachelor of Law and a master's degree from São Paulo University, and is currently a PhD candidate at the same institution. Thank you, Rafael, for joining us today. And last but not least, we have our moderator for this event, my dearest friend, Pedro Tiziotti. Pedro is likewise a São Paulo State Attorney and is a LLM candidate at Harvard Law School. Thank you, Pedro. So no further delay, I invite Pedro to introduce the format of this event. Thank you, Pedro.
Thank you, Jean. It's a great pleasure to co-host this event with you and to have with us inspiring speakers like Professor Mason today, and Rafael. So today, Mason will give a talk on accountability and trust in AI for about 10 minutes, and then Rafael will discuss the connections between AI and public procurement for another 10 minutes. After that, our speakers will answer questions from the audience, so please feel free to send us any questions you would like to ask them. And if you prefer sending questions in Portuguese or Spanish, we will make our best to translate them, okay? Now I will turn the floor over to Mason. Thank you all.
Thank you so much for the introductions, and thank you for the opportunity to be speaking here today. Really excited. Rafael and I actually connected earlier and found out we have a lot of really common interests. So already this has been a great experience for me. But as Pedro mentioned, I wanted to start off by laying out a little bit of a framework to think about accountability and trust for AI and for algorithmic decision-making systems in general. And then I will turn it over to Rafael, who's the expert in a particular form of accountability, which is accountability through the public procurement process. So in terms of a general framework, I think if there's one thing that I would like to impart to the audience today, it is that AI trust and accountability is very unlikely to be a single solution problem. And that's because there's a lot of variation, and that variation occurs in multiple dimensions. So one sense in which there's variation in accountability for AI is across different use case scenarios. So there are a huge number of different uses for artificial intelligence these days. And anyone who checked their social media newsfeed this morning, or used Google Maps to get directions somewhere, or even used a search engine this morning, has interacted with artificial intelligence, or at least algorithmic decision making in some way. And not every use case is likely to demand the same level of trust and accountability. Certainly, for example, when you log on to Netflix or something like that, and it uses an algorithmic decision making engine to recommend the next show you should watch, or something like that, there are absolutely social values embedded in that, and there are places where bias can enter, and there are very good questions we should ask about, like, what sorts of material are recommendation engines surfacing and which are they not. But when you compare that to something like the use of algorithms in the criminal legal system, right, where an algorithmic output may determine the length of a sentence someone gets, or whether a particular piece of evidence is considered reliable in a criminal prosecution, that is demands a different level of trust and accountability. So one thing that I would like to propose is to think about different types of accountability for different use cases of AI. Today we're going to focus a lot on government use of AI because we're going to be talking about the public procurement process. But it's useful to think that there are different interventions that may be more or less appropriate for different use cases of AI. The other point I'd like to raise is that within each use case, there are multiple points of potential intervention, right? So at the most coarse level, you could think about this as kind of pre-deployment versus post-deployment, right? So what are the things that we can do prior to widespread use of an AI system to try our best to ensure that no mistakes are made, that bias is minimized? What can we do kind of ex ante to test a system? And then there is the question of post-deployment. What can we do after deployment to audit a system, to confirm that harm is not being caused? If harm is being caused, what can we do to provide redress? And where appropriate, what can we do to impose liability on someone who maybe had the opportunity to prevent that harm and chose not to, right? And again, these are potentially very different models. Pre-deployment, many people have proposed something kind of along the lines of a popular catchphrase, at least in my circles, the FDA for algorithms, right? The idea that you would have this rigorous testing, and you would have to produce trial data that would be assessed by some sort of centralized agency, and the agency would make a decision about whether that algorithmic system was robust enough, was safe enough for the particular use to which it's being put. Post-deployment, we often talk about adapting traditional forms of liability. So, for example, there's been a lot of discussion about how does product liability factor into use of AI? How does traditional negligence liability, can it be factored into civil rights protections, especially when we talk about, for example, the government using algorithmic systems to make benefits allocations, right? So if the government is using an algorithmic decision-making system to allocate housing or financial aid of some sort, presumably that would fall under the general civil rights protection to which that government is beholden. How do we determine when an algorithm has been discriminatory? These are questions about adapting existing legal structures to an emerging form of decision making. And so these this kind of pre-deployment versus post-deployment deployment, or you could call it ex ante versus ex post, are different methods of regulating. And again, my proposal here is that we shouldn't just be focusing on one. We should actually be looking at multiple points of intervention for any given algorithmic system. And the more impactful that system is, the more points of intervention we should have along the way. I think as Rafael is going to get into, the procurement process, there are a lot of opportunities for pre-deployment interventions in the procurement process, but also requirements as part of procurement for some degree of post-deployment auditing, right? So that's a great way to impose certain restrictions or requirements on especially government use of algorithms. And then the third dichotomy I'd like to raise here is this idea of hard versus soft regulation. And in that, hard regulation would mean generally taking a stance that particular uses of AI or particular types of systems must satisfy certain requirements before they can be used, or maybe cannot be used at all, right? So for example, there are many municipalities here in the United States that have prohibited certain government uses of facial recognition based on the idea that facial recognition technology at this time lacks accuracy, has huge gaps in accuracy based on, for example, gender or the color of a person's skin or age. And many municipalities here in the U.S. have said governments are not allowed to use facial recognition for policing, or they're not allowed to use it to control entry into public housing, because this was something that was experimented with in New York City, and they found that certain people were being locked out of their apartments because their building AI system was not recognizing their face. And so, hard regulation is about putting, breaking points in certain uses of AI technology. Soft regulation, on the other hand, is more of like an incentive-based regulation, right? So, and I think that procurement has a potential to do a lot of this, in that there's competition in the procurement process, potentially, for developers of AI systems to be trying to get out there and compete with each other to make, the most transparent, or the safest, or, the system that works best with the, meets the standards as well as possible. This system of encouraging AI developers to reach for the best practices can also be really effective. Now, I know one thing, I have a little preview because Rafael and I talked about this. One thing that we'll talk about, I think Rafael will talk about, is that a large number of algorithmic decision-making systems used by the government these days are developed in-house. And so, like, sometimes it's a little harder to incentivize adoption in those cases. But these are, I think this is the framework that I think I would love to use to sort of ground this conversation as we dive into procurement and look at how it can be used, how it can be used for different use cases, how it can be used prior to deployment, and what impact it can have post-deployment, and to what extent procurement requirements should be encoded as hard regulations like thou shall or thou shalt not, versus soft regulations saying, laying out best practices and encouraging developers, whether they're private or governmental, to build towards those requirements. So that's my quick spiel, my general overview, and I would love at this point to turn it over to Rafael for a deeper dive into the subject of today, which is the procurement process.
Well, thank you so much, Mason, for this, and thank you also, Gian and Pedro, for your kind words in the introduction, and to Harvard Law School Brazilian Studies Association for putting together this event and hosting this discussion. I'm sharing my screen now. I hope you guys are able to see it. Oops. Here it goes. And I believe that Mason has already covered pretty well the ongoing debate about accountability and trust in AI, especially when you're talking about the public sector. And perhaps my role here and the purpose of this quick presentation is to discuss how procurement sits as a regulatory instrument towards AI, and specifically looking at limitations and bottlenecks of procurement in doing so. So perhaps it would be wise to take a step back and start to think, for example, what is the basic assumption here when trying to use procurement as a regulation instrument. It's wise also to say that, for example, procurement in innovation policy literature is widely recognized as a demand-side innovation policy instrument, which is pretty much a fancy name to say that procurement is a way to create demand for innovations in the market, innovative products, innovative goods, or innovative processes. And if you're talking specifically about AI, for example, we know, and Mason has spoken about this, about the increasing complexity of AI. And please be mindful that I'm using AI here quite broadly. We are aware that AI, and usually we're talking about pretty much machine learning systems and deep learning systems. And this complexity also is even more applicable to deep learning and machine learning algorithms. But this complexity often comes with many negative consequences. There is this website on, if you go to Google and type awful AI, you'll find a repository of many outrageous consequences and negative consequences of artificial intelligence. And literature has been highlighting, however, that the market itself does not provide the necessary incentives to foster the development of ethical and human-centered AI. So if you're lacking incentives, perhaps it would be a good idea to use procurement, use the purchasing power of the state to do so. We're talking about money here. For example, Brazil, we have about nearly 12.5% of GDP dedicated to procurement in all spheres of government. If you go to OECD member countries, it's about 10 to 15%. Anyhow, global south, global north, that's a huge amount of money, and the government has been using a lot of artificial intelligence in their daily activities. So the main assumption here is that if the government is purchasing algorithms, and by procuring algorithms, the government can have this market shaping approach in, for example, fostering this spread of positive externalities in the IT market and developing, for example, better AI systems that originally were manufactured for the government and then are transitioning to private and market-wise broader adoption. However, when you put procurement and innovation in the same phrase, it kind of clashes together, right? Procurement, and I'm using here procurement as more we can broadly relate to, I'm calling regular procurement, usually have two ideas or two main arguments behind. First of all, regular procurement is pretty much interested in getting the government the best value for money. So mistakenly taking like the lowest price, but again, the best value for money for the government. And secondly, trying to prevent and circumvent acts of corruption and collusion. When you're talking about innovation procurement, we're talking about a wide set of different procedures that are not only literature, but already legislation. In the United States, for example, the DoD experience, together with the federal acquisition rules. But if you go to the European Union, you already find a wide set of procedures. And also in Brazil, here in the slide, there's a wide array of instruments that can be used, legal instruments that can be used either for incentivizing research and development activities, and thinking about AI and the IT industry specifically, for example, the regular procurement of AI solutions or IT solutions. AI, however, sits in a tricky place in the intersection sometimes between these two realities. And the intersection of the R&D efforts and IT industry, you have, for example, three main ideas or three types of procedure that you can think about, for example, about using innovation. You have, for example, the Startup Act last year in Brazil created our own model of challenge-based acquisitions. In America, Mason would relate, for example, with the experience of challenge.gov, for example. We have our own set of pre-commercial procurement in the Encomenda Tecnológica, in the Innovation Law of 2004, reformed in 2016. And last year, the new procurement law created our own version of competitive dialogue, inspired most in the European directives of public procurement. But again, innovation procurement and these types of procedure are, firstly, more flexible, especially in the definition of contract terms and in the allocation of intellectual property rights, something that's a key incentive in the development of technology. And secondly, innovation procurement distinguishes itself from regular procurement by focusing in the problem description and not in the object. For example, it means that government entities should not be focusing so much in describing the technical specifications of the object they're trying to purchase, but focusing more in the problem that you're facing. And then letting, for example, private suppliers to say what's the best technological approach to solve that problem. That idea, however, of innovation procurement, and nonetheless the existence, as seen in this slide, for a wide array of instruments that can use to incentivize innovation procurement in Brazil, in the US, and the European Union, for example. And that's pretty much the debate elsewhere, is that innovation procurement is not widely used as it should be. And this is because a single problem, risk aversion. Public officials tend to keep and yield to the overall tendency of using regular procurement, so as they will be exposed to a lower amount of risk. And fighting risk aversion is the biggest debate in innovation procurement. You have, for example, the same scenario, not only in Brazil, but here in the States. I spoke with folks from the Department of Defense, and they face the same. And European Union, the European Commission is funding projects trying to fight risk aversion in the European Union so they can have a wider use of innovation procurement instruments in Europe. The main point here, and perhaps this widespread not use of innovation procurement, is one of the answers of when we take a look, for example, at some numbers, and we recognize something that Mason has already anticipated, is that actual numbers show that in the public sector, a wide majority of applications and AI solutions used by the government are not actually result of procurement processes, but are in-house developments, which means they are systems that were built and developed internally. This is the case, for example, in America. This report, for example, in 2020, shows, for example, the use of AI in the federal American government, but that's also the case of Brazil. For example, information gathered by Transparência Brasil, which is a branch of Transparency International, shows pretty much the same scenario in Brazil. So if you have global south and global north, the green again, and that's something that we have to go deeper into research and find the reasons. One possible cause for this is that governments are still insecure on how they should be purchasing AI. But these by no means means that, for example, this preference for in-house development should not be taken at all as a consideration, for example, that governments already have internal capabilities to design, govern, execute, and audit AI solutions. That's absolutely not the case. And in the IT industry, high-skilled professionals in the IT industry are specifically hard to hire and even harder to retain in their workforce. So that's a huge challenge for governments, because we all know how government HR policies are sometimes not suitable to retaining talents in their workforce. And this point of technical literacy, for example, is also relevant for when you're trying, for example, to procure, and you have this problem of the outsourcing of policy decisions. When governments use artificial intelligence and use automated decision-making, they are usually facing areas of high public scrutiny, like law enforcement, education, healthcare, and benefits, and so on. So if you don't have technical literacy in your workforce, you probably end up, in the end of the day, having the private suppliers' employees deciding where policy should be allocated. And the policy embedded in the algorithm should be transparent and accountable. And that's something that perhaps we might miss if you're not having enough oversight of your private supplier in procuring, in the procurement of algorithms. I believe that I have here enough problems, but that's my last slide and my point here. And to sum it up, my point, and again, agreeing with Mason's initial statement, we are not saying that procurement is worthless. We are saying that procurement is not a silver bullet. We are mentioning that procurement here should be complemented with other regulation instruments, and perhaps some of the great for example, great best practices, recommendations, and things that have been put together in many projects. For example, the project that I'm currently working at the World Economic Forum, but also the IDB has the Fair Lack Initiative, the World Bank, the OECD, UNESCO. They all have been recommending a lot of great best practices to AI procurement. So why not extending and expanding its use towards other types of AI sourcing, like, for example, in-house developments? That's the case, for example, of certifications and third-party auditing, for example. Could be, for example, it could be also wider the use of algorithm impact assessments in the Canadian Directive of Automated Decision-Making, for example, that are specifically directed to procurement, but should be obviously expanded to in-house developments as well, a way to foster and enable better AI accountability in the public sector. We already spoke about enabling and investing in public sector AI expertise, but my final comment would be, for example, for strategies of human oversight. That idea of having a human in the loop, with an expression pretty wide known in the AI lexicon, is pretty much having a human operator validating the outputs, for example, some kinds of high-risk outputs in AI solutions, but putting a human operator to validate the assumptions of a machine also entails its own sets of risks, and risks that should be also mitigated accordingly. You have, for example, the automation bias. If you have a human over-reliant of the algorithm outputs, you're not getting so much oversight from this. But also, you might also face unlawful compensations. Compensations for overcompensations or undercompensations that this human operator might do based on perceived errors of the algorithm that might create distortions to the machine learning model, but also compensation that might not be fair and might not be legal. So one set of risks arising from the use of human operators that, again, should be mitigated accordingly. I believe that I have bored you enough, so thank you so much for this. And thank you so much again, Pedro and Gian, for having me here.
Thank you very much, Rafael and Mason. Now we have some questions for you. We will start with a question for Mason. So the question is, what degree of transparency is required for governments to make informed decisions about AI procurement? And what are some ways of achieving that transparency?
Yeah, thank you, Pedro. And I would also love to hear Rafael's thoughts on this. So I think that in general, for me, the test for transparency is meaningful auditability, right? So is there sufficient transparency that you can audit the operation of the algorithm in an extent that is proportional to the potential harms, right? So again, this goes back to the idea of like, is the transparency that's required of, a movie recommendation algorithm the same as the transparency that's required of a sentencing algorithm in the criminal legal system? To me, the answer is no, right? The latter requires a much greater degree of transparency. I want to know a lot more about how that is working. So, sorry if that's like somewhat of a lawyerly non-answer to say, it's fact dependent, it's about proportionality, but I do think it is important to, to name that there is not a specific, key point of transparency. Rather, it is about being able to achieve meaningful testing on a system. In terms of ways of achieving transparency, this is an area of huge debate in machine learning and algorithmic decision-making generally. I would say the two major models are transparency through explainability and transparency through counterfactuals. So transparency through explainability means that you can either understand the operation of the AI system is understandable to a human, or the AI system is itself capable of generating some human understandable explanation. For relatively simple algorithmic decision-making systems, sometimes the operation is simple enough that a human can look at it and understand the weighting of the variables and say like, okay, I see it. It's weighing these 4 factors in this order. On the other hand, some very complex systems, this is often like, deep neural networks, for example. It's not really helpful to understand the weighting of specific variables and nodes and edges. And instead, there's been work on creating human understandable explanations. So that's one possibility is and this is somewhat of in a way, analogizing to human decision making, saying we should be able to explain the decisions we're making. The other school of thought is that we don't focus on explainability. We allow the algorithms to be essentially black boxes, but we know the inputs and we know the outputs, and we can look for correlations between them. This school of thought says, okay, if I put in A, B, and C and I get out X, Y, and Z, I don't need to know how it arrived at that. I just need to know that there's some kind of causal relationship there. And this is an interesting area because it's where our view of the legal system has really shaped what we want out of AI. So in the US, for example, when you look at civil rights statutes that require non-discrimination, there are, again, 2 lines of thinking. One, that in order to prove discrimination, you need to show discriminatory intent. and on the other, that to show discrimination, you only need to show disparate impact. And these align very well to these two different ideas of transparency. It's essentially, you need to know what the system is, thinking, and I use that word very loosely, but do you need to know the sort of the intent, like why the decision was made, or do you really only need to know the impact? And I think that more and more regulation of algorithms is shifting towards the second, which is to say, if you have a system that allocates medical benefits, and you notice that it is systematically under allocating benefits to people in a certain demographic, do you really need to know why? Do you really need to know the internal operation? I mean, maybe that's useful for the developer to be able to fix it. But in order to say this does not meet our standard for procurement, or we should not use this system in the government, really all you should need to know is the output, the impact that has on people of a particular demographic. So I think more and more we're seeing shifting towards this counterfactual idea that if you can view the inputs and correlate them with specific outputs and robustly test the system that way, you can make do without knowing the inner workings of the system. Ideally, I think we have both, right? Ideally, we have both a transparency of the system as well as the ability to do robust testing. But if I'm talking about like kind of what's the bare minimum here, I would say it's the ability to do input-output testing and make decisions about impact that way.
If I may jump in, Pedro, here, and again, great answer, Mason. I think that these two buckets of your great two schools of thoughts, it's really helpful for understanding what's the bare minimum we can have. But something that's really interesting, and it's somehow correlated to this debate, is, for example, some folks in literature have been defending, for example, that you should have reverse Turing test. For example, you should have, for example, if you have automated decision making, that's great, but perhaps you should keep like some part of that decision making old school human decision making, so you can always have a parameter to compare of comparison, right? And you can, for example, have always a very updated set of information to retrain the algorithm and to retrain the model again. So that's something that perhaps beneficial, more correlated to the second approach again, right, Mason? I'm afraid, because you have this correlation between inputs and outputs, but some practical strategies that could be used to implement transparency in a wider context.
Thank you, Mason and Rafael. Now we have one question for Rafael. You mentioned that the use of innovation procurement is a recommended best practice to purchase AI systems. However, sometimes the use of these procedures won't be possible under local procurement laws and regulations. How should a public entity proceed when innovation procurement is not an option?
Thank you so much, Pedro. Yeah, indeed, that's the great part of our debate in Brazil, right? We do have innovation procurement instruments, but we struggle a lot to use them because, for example, there are exceptions. They are treated like, for example, situations in which you have, for example, to prove there's enough technological risk or a high degree of uncertainty. And this is sometimes really troublesome and can be a hurdle to public entities. Even if I would say that if you're not allowed to use innovation procurement at all, if you don't actually get the chance to use, for example, pre-commercial procurement or challenge-based acquisition, and you have to focus on the definition, for example, in the technical specification stuff, you get, for example, to model your procurement process in a more innovation-friendly way. For example, you can value more technical criteria than price criteria as award criteria, for example. You can use, for example, certifications and independent third-party auditing and the IT skills of the team as, for example, criteria to evaluate the best proposal. So you get, for example, you get a more qualified technical assessment of the supplier and of the system that will come out of that contractual relationship. And you could also try to incorporate some of these best practices into contract requirements, into your terms of reference, in requests for proposals and other procurement bidding documents. For example, You can easily create using contract terms, governance structures, and other recommendations that perhaps will not be helpful to the procurement process, and perhaps will have to, for example, to cope with having a combined relation between price and technical criteria as award criteria to award the contract at the end of the day. But again, you have limited, but you can do something. You have limited options, but you can actually do something. And I believe that, for example, that's the actual choice when we're talking about AI, and especially in the public sector, and the public sector is trying to use AI, and you go deep to the solution itself. It's not in most cases, it's not like a huge thing, right? You're talking about chatbots or sometimes really off the shelf commercial applications that you have wide competition and many different suppliers that can provide that. So perhaps it's properly not the case. You sit more in that circles that I mentioned. You sit more in the IT regular procurement idea, and then you can easily, make the best contract using regular procurement if you value technical specifications and provide enough contractual obligations and you allow the contract terms to be more discussed, for example, with suppliers. You can do this, for example, beforehand. If you do not know, for example, how to purchase a chatbot for our Attorney General's office, for example, Pedro, if we're willing to put a chatbot there to many different uses, perhaps to answer my phone calls while I'm here in San Francisco, it would be great, for example. But again, if we do not know how to do this, a great way is, for example, to publicize that offer. You made, for example, a request of information. You ask for suppliers' feedback, and you get for this open economic debate, for example, you get, for example, a good grasp on how the market feels about the use of that solution in the public. So there are a lot of strategies and a lot of ways to make the best suboptimal scenario if you're not allowed to use innovation procurement in the end of the day.
Thank you, Rafael. Another question to Mason. What do you see as the role of third parties, such as academics and civil society, in the AI procurement process?
Yeah, I think this actually fits really well with what Rafael was just talking about. There are, I think, a lot of places that people who are neither government officials nor technology vendors can get involved. One, so Rafael was just talking about, the government will usually initiate these processes with either a request for information or a request for proposals. I think that's a great place to get third parties involved. Before a government agency puts out an RFI and RFP, they can consult with civil society, they can consult with machine learning experts to say, are we asking the right questions here, right? What should we be soliciting? What is our end goal? And I think that can be a really productive relationship because it can provide a third perspective on what kind of information the government should be soliciting. So that's one place. I think the other place that there's a really good potential for impact here is in the auditing phase. To the extent that governments are willing and able to make logs, essentially input and output logs from certain decision-making processes available, especially to academics, they can really outsource a lot of the number crunching and the looking for patterns. And of course, this becomes like a very sensitive issue in a lot of ways. One, some government agencies are, often cautious about releasing a lot of data to the public for a number of reasons. Some are that, concerns that they don't want to look bad. They don't want to, like, a news article showing up, saying that there was some error in their information processing. But there also are legitimate security concerns about releasing too much information when it comes to these systems that could be potentially exposed to adversarial attacks. There's also a lot of pressure from the vendors often to not make too much information available because they often have intellectual property that they're trying to protect. They don't want necessarily the secret sauce of their algorithmic decision making to get out there in the public and for anyone to be able to recreate that without purchasing the software from them. So there is certainly a balance, and there's sometimes a tension between the government actors, the private vendors, and the third parties in terms of how much information is is shared. But with sufficient information sharing, I think that third parties can play a really important role in the auditing phase. We've seen, I think here in the U.S. we've seen that proceed in a few ways. Some cases cooperatively between the government agency and a third-party researcher or NGO that have agreed to team up to do that kind of research. Sometimes less cooperatively through processes such as the Freedom of Information Act here in the U.S. or other forms of public record accountability acts that would essentially require a government agency to commit to some degree of transparency to turn over some records so that work can be done. I would, of course, love to see more of these, cooperation built in from the beginning so that, during the procurement phase, there's an understanding that certain logs, certain records will be made available for third parties to process for accountability. And I think committing to that stuff ahead of time as part of the procurement process could save a lot of pain down the road when it comes to, what can be, can become a fairly adversarial process about what gets disclosed and what doesn't. So I think that, looking forward and understanding that, maybe today we're talking about, are we going to buy this, this off-the-shelf system for making decisions about who gets loans, but understanding 5 years from now, the question is going to be what information is going to be made public to researchers, what is going to be made public to NGOs that they can do this process and they can add a degree of accountability to the system.
Amazing, thank you, Mason. Now we have one question that either of you can answer. What are some of the main information asymmetries between government entities and suppliers, vendors, and what can be done to mitigate that in the context of public procurement?
I think that I can jump in, perhaps start answering that. There is a huge, that's a great question, by the way. Asymmetries of information is like government contracts, the economic part, when you go to study the economics of government contracts, it's pretty much asymmetries of information. So first of all, technical issues. The supplier always knows best about the product that it's commercializing. So governments always struggle with asymmetries of information. And we're not talking about AI, and Mason already explained that in one of his previous answers. It's really difficult to understand step by step what's the logical of decision making and the pathway of the decision making model. So first of all, absolutely technical illiteracy from the public side is a huge gap. And that's something that hinders, for example, the government and the government staff mainly to be able to actually be integrated into the part of this, the design of the algorithm and how it's going to be used and how it's going to be governed and how it's going to be effectively applied to public policy. That's something, and I would say like the first thing. Secondly, there is a strong use by the industry of trade secrecy, and especially around the source code. Governments also have this fetishist approach towards source codes. They're wondering governments always fancy to have source codes of pretty much everything, and they lack internal capabilities to do anything useful with source code. But I mean, putting that discussion to the side, the industry is also very keen into saying that, for example, the source code is something that's deeply protected by trade secrecy. Sometimes they are right and sometimes they are not right. I think that some parts of the source code are not relevant if you want to assess transparency and accountability, and that those parts should be, yes, shared at least with the public entity, so you can see how the decision-making process is taking place. So I would say that these two, I think we have like a legal argument and we have a practical economical argument, but I mean, these two factors, I believe that they're most relevant in procurement. There are other factors we could say, for example, about opportunistic behavior, adversarial machine learning, if you're going to use, for example, open source code, how can, for example, other suppliers and the supplier itself can use that if having, for example, conflicts of interest or any other opportunistic behavior types of, approaches. But to procurement, I would say the trade secrecy and technical illiteracy would be the most important highlights, but not sure if Mason agrees, if Mason would like to add up to that.
No, I think that's exactly right. And I just wanted to add a little bit on the trade secrecy front, because that is another place if you look at not just the government agency, but the public in general as sort of a third interested party here in terms of knowing what is going on. On one hand, I think there's in a certain level, the ideal situation is that any government algorithmic decision-making system is open to testing by members of the public, right? That you can essentially say, well, if I were to change the inputs, how would the outputs change? And that can be a great way to test for weaknesses in the system. Unfortunately, that also is a great way to test for vulnerabilities that can be taken advantage of. And with enough access, you can actually reverse engineer with pretty high accuracy what the operation of the algorithm is. So I think there's a tension here, because when a vendor is selling an algorithmic decision-making system, essentially what they're selling at the end of the day is a statistical model. It's a complex statistical model. It's often one that is not easily recreated without a great deal of effort. But it is essentially what is being sold as information. And if you have perfect transparency, you're essentially giving the product away for free, right? So I think especially if you're going to leverage innovation procurement, and you're going to leverage encouraging creative solutions for problems, there does need to be a degree of IP protection for the companies. However, I think that there's also a fair argument that that can be taken too far, and trade secrecy can be used to prevent really necessary auditing of systems, right? So I think that this is like one of the big challenges to regulators here, is like navigating that system, right? So that it's not, so there is some product that the vendors are, essentially able to sell, right? This is the sort of kind of incentive structure of intellectual property. But at the same time, recognize that there needs to be some degree of openness. And people have drawn comparisons, for example, to the pharmaceutical approval process, where there's a high degree of openness, but in exchange there's a period, there's a period of exclusive rights. Other people have suggested that this is maybe an area where there can be more secrecy. I think that in many there's a healthy debate about where that balance is going to be struck. But I think that's one of the big challenges that faces AI regulators right now.
Wonderful, thank you, Mason. Another question that is about what you are talking now: how to minimize the bias from the personal input in using AI in procurement.
I can start this one as well. I think that the bias is a question that's much more related to data and the amount of data, how that data is, if data is representative or not of the population that you're trying to use or not. And it doesn't have a lot to do really with procurement. I mean, you can use procurement to mitigate problems arising from biased data, but procurement sometimes is not the silver bullet to answer this question. I would say that government agencies, when they're trying to purchase AI, and there is this hype about using AI right now. So governments really want to say they're using AI, and they're sometimes not actually know what they are doing. But I mean, an important part is recognizing and assessing if this government entity already has enough data and enough quality data. Sometimes they do have data which is scattered in several IT separated systems. So they actually don't have anything to start with AI. That's point number one. And secondly, for example, when we're talking about data quality, mitigating bias and making sure that the data is actually a representative sample of the population that we're actually dealing with is something that's not easy. that requires a lot of technical and IT competences that are really hard to find in the government sector. And I would say that in Brazil, at least, but also I believe here in America and European Union for certain, there are a lot of partnerships between government and civil society, but also with research institutes and universities and academia to try to not only build models, but making sure that the models that are going to be built also reflect in that data and the data samples, a sample that's adequate, it's fair, and it's reasonable, so you can have a better accountability in the AI systems as well. So I think that it's not an easy task, but it's something that has a lot to do with data. And I would say that's even more like a prerequisite for procurement. That's like a step one. We have been calling this in the forum like phase 0. Before bringing up the discussion about procurement, let's take a look at our data. Let's see if you have good quality data to start with, and then we can, for example, mitigate bias and make sure that this unlawful prejudice is not coming out on your algorithm outputs.
Thank you, Rafael. So this is the last question. Should there be different protocols for procuring AI in areas or sectors of high public scrutiny, for example, public security, immigration, and public health? Or can there be a catch-all approach to mitigate possible ethical risks?
Well, I'm happy to give my take first here, which is I strongly believe that there should be different protocols in different sectors. I think that first and foremost, those protocols should be developed with an eye towards what are the risks, what are the potential negative impacts if there is an error, if something is procured that does not operate as intended. I think the more sensitive the error, the more layers of review and the more transparency that is required and the more involvement from a large number of different parties. I think that not every government, not every act of procurement that involves an algorithmic decision-making system necessarily needs to be a multi-year affair, but some absolutely do, right? I think there are some areas of procurement where robust testing beforehand, releasing that test data to the public, allowing academics and civil society and just interested members of the public to analyze that data, making that available to journalists, for example, right? So that it becomes a matter of public attention. Having public debates. I think that, if my municipal government were to consider, obtaining an algorithmic decision-making system for something high priority, like assigning public housing, I would absolutely want there to be multiple rounds of opportunity for public comment. I would want people outside of the government to be involved from the very first request for information. On the other hand, if they're using an AI system for something like managing their internal file systems, I think that that's important, and I think that that should be known, but I don't know that I would expect it to be exposed to the same degree of scrutiny. So I think that, I think it's really important to not think of, necessarily AI or algorithms as the target of the regulation, but to think of immigration or public health as the target of the regulation, and to think, is this a heightened area of scrutiny? So I tend to strongly fall into the camp of saying that there should be different protocols for procuring AI in different public sectors.
If I may jump here, I strongly agree with that. That's also one of the questions that Mason and I previously, when discussing this event, we chat about. But again, I strongly agree with Mason that you should be having, for example, independent protocols and sector protocols. And this context-specific protocols sometimes are more useful and more detailed than something that's really general. I really like, however, the idea, for example, in Canada, putting together a directive on automated decision-making, which something's very general. You have like a broad ideas about the use of artificial intelligence in decision-making in the public sphere, let's say. But you also must have, like, alongside with this general regulation, context-specific regulations. For example, in Brazil, we already have two sectorial regulation in AI. We have one in the Ministry of Health, and we have one in the National Council of Justice about the use of AI in the judicial system. So it's interesting to see, for example, how Brazil sector regulations began first. And now we are discussing the national AI strategy, the national Estratégia Brasileira de Inteligência Artificial, our own version of national AI policies. And we still do not have this general act. There's a bill in the Congress, not focusing on the right questions, I'm afraid. But again, it's interesting to see how this mix and match of general and context specific is a good fit for regulation. I believe that's the best fit of AI regulation.
Thank you, Rafael. So now I want to leave the floor open. If you want to do final remarks, Rafael or Mason, please feel free.
Sure. So just, I'd love to take this opportunity to respond a little bit to some of the great points that Rafael has brought up about procurement. So one thing that I think is, kind of connecting the, sort of bigger picture AI regulation to the specific discussion about procurement is, I think one thing that's often not thought about in the procurement process, at least in my experience with procurement here in the U.S., is that it is not a process that stops when the purchase order is entered, right? Oftentimes here in the US, procurement really support for the procurement process ends when the software is bought and installed on the servers. And there is really little thought given to post-deployment assessment of whether the procurement process went well. And I think that really cultivating a culture, this is not true actually really in any way. It is not limited at all to AI or algorithms. I think in general, cultivating a culture that when the government engages in a procurement process, that there is a reflective period afterwards to look back and understand where the process went well, where the process went wrong, and what can be done better next time would be, huge improvement. I hope that the discussion around procurement of AI systems in particular might spur a cultural shift in government to say that, procurement is an ongoing process. It includes auditing, it includes looking back on the process, and includes trying to do better the next time around. And I understand, like, saying this, that so many government agencies are running on a shoestring budget and often, like, understaffed and overworked. There's a number of kind of systematic issues here, but I do hope that that's something that these discussions, these really healthy discussions around the procurement process will help bring to the surface.
Mason, your point is excellent. You're absolutely right. We usually say that procurement, we're focusing too much, like, for example, in the procurement process, and sometimes the contract execution, when the problems take place, are somehow not receiving the same degrees of attention. We usually say that's pretty much like marriage. It's pretty much when the problems start to happen. But again, I think that that's an important point, and we should be broadening our view, not only focusing the procurement process itself. The procurement, you're taking like pictures, for example, you're talking about certifications. It's a way of correcting asymmetries of information. If you're talking about market engagement, you're seeing a specific moment between buyer and supplier interacting towards getting, for example, the state the best value for money. But again, the problems and the execution, and this is going to take place in contract execution. So it's a great point. I strongly agree with that. And we should be, embedding all these discussions about procurement into this longer cycle, life cycle of the solution itself, not only the contract, but the life cycle of the solution itself. So it's actually a great point. And as final remarks, only would like to thank our audience, but also Mason, Pedro, and Gian for putting together this. Thank you so much for having me. It was great fun to have this discussion this Friday morning for me in Pacific time, and looking forward to next interactions. Thank you so much.
Thank you very much, Rafael and Mason. Rafael, I will have to disagree with just one point. I think that marriage is a honeymoon. I hope that my wife here listens to that. And I hope you have a great day. Thank you very much for your wonderful speech. It was a pleasure to have you with us.
Thank you again, Jean, Pedro, for hosting, and Rafael. excellent to, I'm really glad to have been able to share this time with you and connect with you.
Thank you so
Thank
much.
you.
Bye,
We're gonna make
everyone.
the recording available for everyone.
Great.
Thank you so much.
Bye-bye.
Ryan.
Bye-bye. Thank
Have
you.
a nice afternoon.